No, I just come in.
Let Rico Hill's office know that yes, still have some time. In fact, if you want to come that day, you're going to fly that day. You always got to do
Right.
this guy, Lacey,
That's the man that I have to lose. Come back.
Makes it easy. Huh? Like 10 minutes. They're going to say no, they're going to leave.
You went there for my note. Christian story.
Mr. Galmore is in lockup. He just wanted me to give him whatever. Appreciate it.
Yes, sir. Just what I told the gentleman, good to the mic. He is what he is. He should be.
Well, I'm not trying to say yet.
I understand he's dropped it unusual. All right. But thank you for, James, thank you for letting me know about it.
Yes, sir.
Appreciate it. I have no problem.
You knew you were coming.
Right, let the record reflect that Mr. Moore is present. Good afternoon, Mr. Moore. We're here to hear the motion for change of venue, which has been filed. And first, let me say thank you all for your briefing and memorandum submitted with it, and all the attachments. I've reviewed those thoroughly. Jim, I'll be happy to hear from you now any oral arguments in addition you wish to make.
Well, Your Honor, just to set the record, this case was initially tried June 20th of this year, and that resulted in a mistrial. The defendant filed a motion for a change of venue on or about June 26th of this year. We filed a supporting memorandum and affidavit along with that. Your Honor, in looking at a motion for a change of venue, it's my understanding that change of venue is addressed to the sound discretion of the trial court and will not be disturbed on appeal absent an abuse of discretion. So that means this issue is squarely in the court's jurisdiction here today. In looking at the relevant statutes and case law, specifically South Carolina Code 172180 and State v. Manning 495, Southeast 2nd 191, one of the things that jumped out to me was the language of the Supreme Court. They said mere exposure to pretrial publicity does not automatically disqualify a prospective juror. Instead, the relevant question is not whether the community remembered the case, but whether the jurors had such fixed opinions that they could not judge impartially the guilt of the accused. We submit that that is exactly the problem here in this case. We have submitted an affidavit in addition to our memorandum, and it speaks for itself, but it does express to me that there are concerns. There are concerns about jurors, their safety, and more importantly, the community reaction to them being on a jury. I guess to say it succinctly, juror cannot be fair and impartial if he's being bombarded or overwhelmed with community discussion. Why did you vote that way? Things of that nature. It's for that reason that we'd ask the court to grant our motion for change of venue. We simply stand by our memorandum and supporting documents. Thank you for your attention.
Listen, we'd have to hear from you.
Thank you, Judge.
Yes, ma'am.
Your Honor, it is the state's understanding that you've already decided to change the venue in this case and move the trial to Georgetown. We do respect that decision, but we do want to put our argument on the record just to protect the record.
Just for your edification, I denied a motion for directed verdict in the case that I just granted a directed verdict. So I'll be happy to hear from you. So,
thank you, Judge. I'm going to keep it brief. Like I said, I understand you've already made the ruling.
Well, I know I just said.
The first thing the
I
state...
ruled on directed verdict before lunch, and I granted directed verdict after lunch. So I changed my mind in the last 2 hours. So I'll be happy to hear from you.
Thank you, Judge. The first thing the state wants to do, just to protect the record, is put into an exhibit. These are the questionnaires of the jurors that were filled out earlier. These are the questionnaires of jurors that came back that said they could be fair and impartial. There are about 100 questionnaires that came back that they could be fair and impartial. I also have a notebook that I'm going to put in a state's exhibit as well. These are the 30 jurors that came back that said they could not be fair and impartial. Due to the fact that the questionnaires have come back and 100 people have said that they can be fair and unbiased, the state believes that we can get a fair trial here in Horry County, and there's no indication without voir diring the jury that we cannot get a fair trial. The state asks, if nothing else, due to the abundance of case law, that the process be followed through. That the jury comes in and we have an opportunity to voir dire this jury. Now, 100 people have said they could be fair and unbiased. Once we get them here, it may be 90, it may be 80, it may be 100, it may be 50. We're just asking, due to the fact that there has been so many jurors that say they can be fair and unbiased.
How many, just for curiosity, I don't have that number in my head, how many were indicated questionnaires in the first trial that were fair and so could be fair and impartial?
Your Honor, there was actually more. I looked through all the juror questionnaires for the first one and the second one. And Mr. Truslow is not here, but he can tell you it's very time consuming.
Well, I understand that, but I'm just asking you, because I remember there was a figure, but I just don't remember what that figure was.
There were multiple, there were actually more in the first trial that not only said they could not be fair, but the juror questionnaires had information on them that were not only cannot not be fair, but I think this young woman has been killed, and I think you should look over under the defendant's driveway.
Right.
I didn't see anything like that in this jury pool. The questionnaires from the first jury pool, I can probably get them back. They were much more egregious in the extra comments as to not only do I think they're guilty, but A, B, and C. Not only do I think they're guilty of kidnapping, but murder, and so on. So the first juror questionnaires were a lot more egregious than this questionnaire. And to be honest, there were more people that I thought in this questionnaire that said they couldn't be fair to us. There were several in there that said, I can't give the state a fair trial. I've seen a portion of it. I've heard it on the news. I don't think that's enough. Without seeing this woman, the body is missing, it's not enough for me. So in saying that and believing we were able to pull a jury pool from the first trial, I believe we can pull a jury pool from the second trial. Like I say, I haven't seen anything in these juror questionnaires that lead me to believe that we can't, and they're a lot less egregious, to be honest with you, in the comments. So the state has got to object to a change of venue, just because we do believe that the rule is if we can get a fair trial here, this is the venue. This defendant has the right to be tried here, to really to benefit from his good reputation in the community. It's actually set out for his benefit to, for his reputation. You know, this is a man that works, all that's been established through the system. But we believe we can get a fair trial. Now, so of course we are objecting to the change of venue. Now, I understand earlier that it was not only that we were going to change the venue, but that we were also going to change the venue to Georgetown. Now, in,
Let's be clear what we said. I shared with you what the statute says.
okay,
The statute says if I change venue from one county in a circuit, then it goes to the other county in the circuit. That's what the law says.
okay,
Okay, so let's be clear when you state something. I haven't ruled yet, period, okay?
okay, thank you, Judge.
And please, for the record, I'm not angry with Ms. Livesay. I understand some things I need to speak louder, and that's why I'm doing that, Ms. Livesay.
Thank you. Thank you, Judge. As to that issue, as to the change of venue and the statute, my understanding is this change of venue is due to publicity. There's no doubt there's been a lot of publicity, even with the gag order, and it was live streamed. I think that was the big issue for a lot of people. So I actually took a look, and I'd like to put this into as a state's exhibit. And what I found was Georgetown is actually the same media outlet as Horry County. So anything that was live streamed or that was put in the media in Horry County was put in as well in Georgetown, Florence, and Marion. Not only that, but there is not another news outlet in Georgetown. So their sole news provider is the channels that you see here today.
So let me ask you a question. So you're saying that if I could find that there's a reason to believe that a fair and impartial trial because of the fact that the media's coverage is in Georgetown, I should just ignore the statute and take it someplace else as it was happened in the case in 1924 in Charleston?
If I can, Judge. Yes, sir. Can I address that?
Well, I'm asking you because
Yes.
you're saying Georgetown wouldn't be the place to go because they have the same media coverage.
Yes, sir. And I was going to put this in as a
Well, that's
state's
fine.
exhibit. Thank you. This is just showing the coverage in Horry County and in Georgetown. There is a case on point on that, Judge. And I was looking at this earlier, and I'm very familiar with the case that you're speaking about. And I actually ran off a copy.
I've had a copy of it.
This is a different one, Judge. I'm looking at State v. Law.
What?
Is that the same one?
State v. which one?
Let me see if I have I thought I brought up, because I thought you were looking at Harvey.
Well, I've looked at Harvey. That was the one that I was
Yes,
just
sir.
referencing. That was, I'd be happy to look at any other case.
Thank you. Can I hand this
Yeah,
to
and
you?
just for the record, we gave you an opportunity to provide all of this before today too, didn't we?
Yes, sir,
Yes.
Your Honor.
Thank you, ma'am.
State v. Law.
I know
puts
about
up-
Manny
Thank-
Law, yes. I'm familiar with this case. Judge Weatherford's case. Okay. I'm familiar. Go ahead and argue your point.
What this case says is, yes, the statute exists. The statute says if it's to change venue, then it is to change it in the county, in the circuit that you're already in. So Horry and Georgetown are the 15th Judicial Circuit. So the statute says if you're in Horry, then to move it to Georgetown. But what this case says is the provision in that statute is not meant to confine a judge to the point where this man cannot get a fair trial.
I understand that.
So this case says, yes, but if he can't get a fair trial in Horry, and the media is the same in Georgetown, and he can't get a fair trial in Georgetown, then the judge has the authority to move the trial to another county to ensure that he gets a fair trial. So what our argument is we understand the circumstances of the publicity, but we believe if we can't get a fair trial here in Horry, there's 309,000 people in Horry County. There's 61,000 in Georgetown. We believe if we can't get 12 out of the 309 here in Horry, then we definitely cannot get 12 out of the 61,000 in Georgetown, especially with the media coverage being identical in both counties. And we have a lot of issues here where there are families on both sides. And there's families that live in close proximity, Merle's Inlet, in the Georgetown area, due to the fact that they are right beside each other. So we wouldn't be able to get away from those factors. So the state believes, first, that we can get a fair trial in Horry, and if we can't get a fair trial in Horry, we're probably less likely in a county with only 61,000 with the same media outlet to be able to get a fair trial. So we ask if the venue is moved, that it be moved to a county outside of the media coverage of Horry, Georgetown, Florence, and Marion. Those are the counties that these stations all give news media to.
Okay.
And the media outlets national have also been, showing, but I think we could get a jury somewhere else. Now, we talked a little bit at the first hearing, which was on July 29th, and that was with Your Honor. And at that time, and I want to say I'm in complete agreement in the court. I think your first concern there was the fairness for Sidney Moorer, and that is our first concern. And in that, you wanted to find a county that had the same demographics.
Now let's clarify that, because I mentioned that because that's what I did in the case, and we talked about it at lunchtime. That dealt with, and the reason the demographics have a play is because that was in a capital murder case in Sumter where I tried it, and there's a totally different element that has to be considered in a capital murder case regarding a jury, because a jury actually determines the punishment. So that's why the demographics have to be important. The guilt or innocence of a person accused of a crime, the demographics don't have anything to do with that. It's based on beyond reasonable doubt. So don't be relying on demographic situation, because that doesn't have anything to do with it. One of the things that we do have to do, and you have to understand this statute also, the subsequent statute talks about one of the factors is a cost to the county, because the county is going to have to pay for it. And so that's another factor that has to be when we're talking about moving. So those are things that are critical. Demographics has nothing to do with this decision that I'm making today.
Your Honor, can I read from the transcript?
You can read from it, and I told you I was confusing that, and I've explained to you in private, and I'll be happy to take. I just put it on the record. That's in a capital murder case, and the reason for it is simply this: the jury has a different role in a capital murder case than a criminal case, a normal criminal case.
Yes, sir. And Your Honor, the state's only concern is we want to give Sidney Moorer a fair trial, and
Well,
we want to give him a trial of his peers. And we believe the only way to do that is to go to another county where the demographics are similar, because we believe that the peer group here in Horry County would be the same as if we went to another similar demographic. So we asked for that just in trying to give the defendant a fair trial. But we understand the court's concerns. We just wanted to put our objection on the record. We respect your ruling.
That's fine. You don't. I haven't ruled. In fact, I haven't seen any of this. So, and I gave you an opportunity to submit a lot of this, but it's odd that it comes today. So obviously, I'm gonna have to review all of that because I haven't had a chance to review it.
I'm sorry, that's my fault, Your Honor.
Well, I'm not blaming anybody. I'm just simply stating I'm prepared, but as I indicated to you, I changed my mind. I reviewed some things at lunch, and I read some more case law that changed my mind in that case. I'm going to read all of this, so that's fine. Not a problem. Mr. Gup, you wish to respond?
Just briefly, Your Honor, our concern here is that we get jurors who are going to try this case and render a verdict according to the law and evidence, and not render a verdict based on what will my neighbors think when I get back home. That was a concern that was brought out in the affidavit. That is our concern today. We believe that concern can be addressed by changing venue to a different county, and we believe that if the court selects Georgetown County in accordance with 172185, it meets the logistical requirements, it meets the expense requirements, and it meets the requirements of not having the jurors that live in this county so that they don't get bombarded with that particular issue. When they go home at night, the Georgetown County prospective jurors are not going to be harassed about the reasons why they voted the way they did. That's our argument in a nutshell.
Okay. And as I understand, just one second, Ms. Weiss. As I understand, one of the issues that was mentioned in the State v. Manning, where the state moved to change venue and was grounded and the court reversed it and recognized something very significant has been alluded to, but the Constitution provides that the defendant has a right to be tried in the county where the alleged crime occurs.
Yes, sir.
And really doesn't matter whether his peer group was there or not. That I assume is inferred basically, but that doesn't necessarily hold true all the time, as we who do this for a living understand that. But in this particular case, it's Mr. Moore's desire to have this matter removed from the county where the crime occurred and where he in fact resides. Is that correct?
Yes, sir. You must be reading my notes. It is the defendant's right, and he is the person that wants to waive that right in this case. We appreciate the state and their interest in protecting his rights, but Mr. Moore does have attorneys that are capable of doing that.
Thank you, sir. Now, Ms. Lysell, you were going to...
Thank you.
Yes, ma'am.
Just very briefly, I know, I don't know if Mr. Galmore, he wasn't here during the first trial, but there were some concerns that he is discussing here, and my investigator actually spoke with most of the jurors when this came to our attention. And it seemed like the juror that he's talking about we also became acquainted with. And that juror also put on his juror questionnaire that he was friends with both Kirk Treslow and Greg McCollum. And he also put that he knew about the case from the news, but he could be fair and unbiased.
Right.
So I'm not sure, a lot of this is hearsay, what a juror is telling us at a later date. And we certainly don't have that juror here to question his intentions.
I understand, but I have an affidavit of a juror that's expressed some concerns, and I have judicial notice of a juror, which I've shared with you, that came up and asked me why I didn't excuse Mr. Truslow, and the reason I didn't excuse, and you know this is a law, a juror responds and says, I can be fair and impartial, that ends the inquiry. I can't say I don't believe you. That doesn't make any sense. I'm not allowed to do that. Therein lies the issue with respect to many of these things. I want to read them all, but we had a number of people who said that. The affidavit expresses some concerns that there were concerns about going back into the community, not so much from anything that they do, but from the repercussions of what they do. And my concern is, in fact, the question comes up, if I don't vote not guilty, as you stated, there may be plenty of people that said the state can't prove its case. One of the problems, and you have addressed something of major concern to me, that I don't think is addressed in any decision I've seen with respect to stating or waiting for the jury to arrive and making the determination. And that is the fact that we have people that have watched this trial and watched the same evidence. And the concern that the court has, and I'm not suggesting they don't exist in Georgetown or anywhere else, but I think the likelihood, the further we remove ourselves, you may be right. I'm not ruling on this, but I would articulate this. It may not be in Georgetown, but before I can say Georgetown can't be, I think we've got to go through the process there if I choose to move it to Georgetown. I think that would be a mistake with respect to immediately just say the statute, we don't follow the statute, because as we've discussed, the statute is shattered. That's what it says, and I agree there are other decisions that say you're not bound, it doesn't restrain the court, but I think that the court has to have, I have to articulate some basis for why not to follow the statute. At this juncture, I understand the concern about the publicity. It's not so much the publicity, it's the fact that, and this isn't a criticism of this community. I admire this community. There's some close, this is a large community, but there's closeness in this community that is really admirable. People care for each other, and that's wonderful. And we live, and we can't ignore. I'd love to have seen some of these decisions in Manning and Lee, because I remember the Lee case, that if we'd have had social media then, we would have had a lot of other information. The concern the court has is what's been in several of the postings. And I understand that's not an indictment for everybody in this community. It just simply is evidence of thought process. Just as you said, suppose those persons put on there, you know what, because we saw several posts. I know how to get around that. All you got to do is tell the judge I can be fair and impartial, and that's it. Well, that's true in anything we have. But the bottom line, I mean, every case we try, that's always the case. I'm not ready to change the system. But by the same token, if I can eliminate the concerns expressed in the affidavit about if I vote a certain way, there's going to be repercussion beyond this, where I lived. That doesn't need to be a factor. Now, I'll grant you, there may be family members in Georgetown. I don't know how many there would be. I would say to you, the likelihood of someone living next to somebody that is taken aside in Georgetown versus here, I think is probably significant. However, I'm not ruling and not suggesting, and I'm not ruling either way, because I want you, everyone is here, and I'm going to read this and then I'll announce my ruling. It will be in an order, but so that you understand my thought process, and they will have the benefit of that. That's my concern. The media part, to be honest with you, I agree with you. If all we were dealing with was just the newspaper reports, from what I've observed, they've done a tremendous job. I don't have any problem with it. It's the problem that I have, that I've seen expressed in the affidavit and some of the social media, of the nightmare situation that we have. And you may be correct. I don't know. We may have to do an individual voir dire in Georgetown to make sure that we can possibly address any concerns. But to be candid with you, reluctant to say this because it's being seen, but Grisham made a lot of money on runaway jewelry, and that's exactly what we're talking about. So I hope you're not suggesting that we have to go to the end of the state, because if we start that precedent, the cost to the county is going to be astronomical.
I understand that.
And that's a concern that I have to place, because there's no question if we go to Georgetown, the probability is, as I would do here, and it did. We didn't sequester the jury. I trust the jury to honor the oath that they took. But if we go somewhere else, as you talked about, because of, well, one of the major things, and I don't disagree with you, we'll go have a viewing, have the same trip that we took. Very significant, very important to the state's case, and I think unless something comes up with which I'm not familiar at this point, the retrial will have that viewing. But in order to do that, we'll have to bring the jury back, so we'll have to sequester them for the entire time of the trial. That's an expense that doesn't have to be addressed if we can get a jury in Georgetown County. That's my concern.
Yes, sir, Your Honor. And the only thing we're asking, and I'm not arguing with you.
Well, you can argue with me, that's fine.
The only thing that we're asking for is to first try to do this voir dire here in Horry before any decision is made. And I only ask that because, reading through those juror questionnaires, quite honestly, sometimes it can hurt your feelings, because there were 30-some people that didn't know any of us or anything about the case.
Well, I understand that.
I think there's definitely people out there that have no idea this is going on in Horry County.
And my response to you is this. I don't know how many of those persons, they said the same thing in O.J. Simpson trial. They wanted to get people that hadn't seen or heard anything about O.J. Simpson. That's kind of scary when we all watched the Bronco chase and all the other things that took place. And I want somebody that's never seen that or has no familiarity with that. What does that cause me to think right off the bat? Are they being totally honest about that? And therein lies the concern that I have, because we have that expressed in a number. The juror said he was a friend of the defense counsel. Okay, that happens all the time, but that doesn't prevent a juror from sitting. We know that happens every day. So the concern is there, and my thought is this: from the standpoint of review, why do you want to create the issue of having to retry this 5 years later?
Your Honor, and honestly, I'm not trying to create an issue.
Well, I'm just asking you, because that's one of the things I have to think about.
I understand, and I
And
couldn't be.
and this is really for the family of the victim in this case. The worst thing in the world is to have to come back and try it 3 or 4 years later and things happen, so.
And if I may, Judge, and I'm probably telling a lot about myself, I don't watch the local news, so I'm not shocked that there's 30 people that don't know anything about this case. I don't really know anything that goes on outside of the cases I have. So I'm not shocked that there's 30 people that don't know anything about this case. Horry County is one of the biggest counties in South Carolina. It stretches out from Myrtle Beach to Green Sea to Socastee to Merle's
I'm
Inlet.
talking to somebody that lives in the largest county in the state.
There is a broad spectrum of demographics and people in Horry County, so I think some are definitely more informed than others, and I don't question that one, because they watch the news, is any more educated or better to be a juror than the one that does not.
Well, I agree with you.
And I believe that the case law lays out the process, and I don't think I'd be doing my job if I didn't ask the court to follow that process, because the guy in Columbia that's getting tried, I want the same rules for him as the guy here in Horry County and the guy in Charleston, because we've had umpteen death penalty cases tried 2 or 3 times in the same county.
I know.
And in those counties, those jurors don't even know, not only know that it was hung, but they knew that this man was found guilty, and 12 people said, put this man to death.
I understand.
The second jury came back in, and they were able to pick a jury right there in the same county. We've had people tried for the death penalty in the same county numerous times.
I understand that, but the difference is quite simply this. This trial will reflect, with maybe some additional witnesses, exactly what was seen, correct? I mean, we know that there's a transcript. There's everything there. Everybody's going to hear the same testimony again. And therein lies the issue, one of the issues that we don't have in any of these cases, any of them. We have publicity, we have newspaper reporting, but we don't have people that have watched the trial.
Your Honor, and I don't know without, and here's my biggest concern, I don't know without us asking the people in Horry County who has watched all the trials. I'm going to be honest, I assume that
The
most people
questionnaire
are at
doesn't
work.
address that, does it?
I mean, I'm assuming that most people are at work, so they can't watch it all the time. I
Does
mean,
the questionnaire address that? I didn't see it.
The questionnaire does, Your Honor. They address whether or not, and I'll give you the one from the guy that did the affidavit. It's the same
No, I understand.
as
It's
the
same
one that we did last time. It asks whether or not they know the defendant through any sort of news.
Is there a question, did any of you watch the trial? I didn't see that.
It did not, but most of the jurors up there actually said, yes, from news, I watched portions of the trial.
Okay.
So most of them actually said, yes, I read about it in the paper, or I saw it on the internet, or I watched portions of the trial. So most of them volunteered the information.
All right. All right, anything else from the state?
Nothing further, Judge. I just want to mark this as a state's exhibit since the affidavit was marked, and that way I can include this with the affidavit
Yeah.
since that was that particular juror's
For the
questionnaire.
future, Ms. Livesay, when you submit something to me and we set up a hearing, I want it beforehand, okay, as we did for everybody else.
Yes, sir.
Thank you very much. Anything further?
No, sir.
All right, I'm going to review what the submissions the state has given me today. Thank you very much. We'll probably just announce it, and one of you will be called upon to draft the order.
Yes, sir.
Thank you very much.
Thank you, Judge.
And as for the rest, I appreciate your need to know, and I understand that. You have to understand I'm prohibited from talking about this case, so there's no need to call me, ask me. When the decision's handed down, it'll be made available for your review. it'll be filed on record here in order. But thank you all for your patience with that. Appreciate it. All right, that will be in recess.
Thank you, Greg.
Thank you.
We're coming out of break. Y'all wait for anything?
All right.
You need to go, come on, y'all need to wait for something too?
All right. Okay,
All right.
because I'm gonna need to look out. I'll try to finish it while I'm here, so take them with me.
So they're waiting.
I'll do that.
Yeah, they're waiting for something from them too, from, I don't know what.
Yes, ma'am. Y'all have a great day.
All right, now they're ready. They're ready.
Yeah, Martin, go ahead. Thank you.
Thank you.
Watch your back, Paul.
He said that I want to make sure that I have it right for my signature. Was he saying that he doesn't like it on social media? Basically, people could see a social media post that says, the judge says all those Sunday versus things, they can be very social, he can't dismiss them. And he basically doesn't like it. Okay, that was his social media concern, in addition to the affidavit concern about the repercussions. Okay, that's okay. Which is funny, because I literally tweeted something about that. I just wanted to make sure I had it first.
All right, everybody.
Nancy, do you want this all like separately or separately?
Judge, I'm sorry about that. I thought